Good day, class. This is Attorney Season. Welcome to Criminal Law Book 1. Today, I'll be discussing Article 6 of the Revised Penal Code. So, Article 6 talks about consummated, frustrated, and attempted felonies. And under this article, consummated felonies, frustrated felonies, and attempted felonies are punishable. Example, uh, attempted murder, it is punishable. Frustrated murder, that's also punishable. And of course, consummated murder, that's punishable under the revised penal code. So when is a felony consummated? So a felony is consummated when all the elements necessary for its execution and accomplishment are present. Um, let's just say murder. So in murder, there's always intent to kill. So once the offender killed the victim, that's consummated already because all the elements necessary for its execution and accomplishment are present. The victim died. Okay? And when is a felony frustrated? When the offender performs all acts of execution which would produce the felony as a consequence, but which nevertheless do not produce it by reason of causes independent of the will of the perpetrator. Let's just say uh, A uh, mortally wounded B using a bladed knife. However, okay, due to medical intervention, B survived. Okay, and without medical intervention, B would have died. Therefore, it is frustrated. Why is that example frustrated? This frustrated because the felony, the offender performs all acts of execution. A mortally wounded B. Okay, and that could result, okay, when A mortally wounded B, that could result to the death of B, okay, and it will be consummated. However, the felony is not produced. Why? By reason of causes independent of the will of the perpetrator due to the medical intervention of a doctor. That's why B did not die, okay, because B was treated, okay. So therefore, the crime is the frustrated stage. And there is an attempt when the offender commences the commission of a felony directly or by overt acts and does not perform all acts of execution which should produce the felony by reason of some cause or accident other than his own spontaneous desistance. Say for example, okay, there is an attempt when A, okay, with intent to kill B, shot B. However, he missed. Okay? Therefore, this attempted. Because the offender, A, Mr. A, commences the commission of a felony by overt acts. So with intent to kill. So he shot B, but however, he missed. Okay? And does not perform all acts of execution, which should produce the felony by reason of some cause. The cause is that he missed. Okay? Other than his own spontaneous resistance. If you will not miss, then B, the victim, could have suffered frustrated or consummated murder, could have died. Okay? So we have here two phases in the commission of the crime. Number two, number one, subjective phase, and second, objective phase. What's the difference between subjective phase and objective phase? So subjective phase is the portion of the commission of the act wherein the offender commences the commission of the crime after the time that he has control over his acts. So keyword, when we talk about subjective phase, the offender still has control of his acts. This refers to the attempted stage or okay, attempted stage. Example, A wanted to kill B. So, nagpagawa siya sa iyang gun, then pointed it to B. However, he has a change of heart. He doesn't want to kill B anymore. Therefore, iyang gibalik kung sulod ang pusil sa iyang bulsa. So, the offender still has control over his acts. Therefore, dili pa siya liable in killing D. Kaya wala niya gidayon. Okay, so it's still in the attempted stage. The offender still has control over his acts. Pwede niyang pusilon, pwede po niyang dili na lang pusilon. Okay, napa siya control sa acts. So he may or may not proceed in the commission of the crime. He still has control over his acts. Next, objective phase. So from the moment the offender loses control over his acts, it is already in the objective phase of the commission of the crime. Okay, say for example, A wanted to kill B. So A took out a gun and then pointed it at B, then fired at B. Okay, therefore, okay, this is the offender loses control over his acts. It is already in the objective phase of the commission of the crime. Why? Dili naman maka-ingon si B nga stop. Di na niya pwede ma-stop ang bullet ni tira na. Therefore, the crime could have been frustrated na or consummated if ever. So, pwede consummated murder or frustrated murder if there's medical intervention. So, wala na control sa offender. Napisil naman niya. Naigo na si B. So, wala na siya choice. But, wala na siya choice na, wala na siya way para dili na idayon offense. Na-commit na niya. Wala na siya control as to its result. So, it can either be frustrated if na ay medical intervention or consummated if the victim died. So stages in the development of the crime, we have here internal acts and external acts. So what's the difference between internal acts and external acts? Internal acts are not punishable as a general rule, not punishable. So mere criminal thoughts will never give rise to criminal liability. There should be an external act. Let's just say, naguna-una kang weapon si Maria. Okay, a person, naguna-una nga weapon niya si Maria. Iya naman gihuna-una. Therefore, it's only an internal act and not punishable. Mere criminal, again, as a general rule, mere criminal thoughts will never give rise to criminal liability. However, if gahuna-una siya that he will rape Maria and then he performed overt acts of rape, okay, then that's a different story. He cannot be liable for attempted rape or consummated rape, as the case may be. External acts are acts which includes preparatory acts and acts of execution. Okay, and as a rule, preparatory acts are not yet punishable because they are not yet connected to a particular felony. For example of preparatory acts, we have here conspiracy to commit a crime of robbery. So nagsabot mo, you conspired with someone to commit robbery, or you proposed to someone nga mag-commit siya robbery, etc. So it's merely preparatory acts and not punishable. Unless, of course, if the law or the revised penal code provides that conspiracy to commit a crime or proposal to commit a crime is punishable. So one good example is conspiracy and proposal to commit treason under the revised penal code. And if you will conspire or propose to commit treason, you can be held punishable. Okay, that's the exception. Acts of execution, we have here attempted, frustrated, and consummated stage. So there is an attempt when the offender commences the commission of a felony directly or overt acts and does not perform all acts of execution, which would produce the felony by reason of some cause or accident other than his own spontaneous resistance. So in this case, the offender is still in the subjective phase. The offender still has control over his acts, whether to continue the commission of the crime or not. Okay, still, pwede ba niya, if ever he wants to kill someone, the offender still has a chance to back out in committing the crime because he still has control over his acts. So the offender still control over his acts. He may proceed in the commission of the crime or he may desist if he wants to. So the moment he desists on his own spontaneous desistance, then he will no longer be held criminally liable because there's no overt acts na. Okay? The following are the elements of attempted felony. Offender commences the commission of the felony directly by overt acts. That he does not perform all acts of execution, it would have produced a felony. His acts was not stopped by his own spontaneous desistance. That he was not able to perform all acts of execution by reason of some cause or accident other than his own spontaneous desistance. So what do you mean by overt acts? So it refers to any external acts which, if allowed to continue, will naturally and logically ripen to a crime. And what the law requires is that the overt act must be directly connected to the intended felony. And the offender commences the commission of the crime directly by overt act. So what's the overt act of murder? Okay, what's the overt act of murder? Just a question. Okay, when someone, okay, stabs a person or mortally wounds a person, okay, then the victim would have been killed, right? So that's murder. When you stab someone at the back or shoot someone at the back or at point blank, okay, there's treachery there. Therefore, that's murder. Okay? And of course, when you shoot someone, dili po na mo ripen. It will ripen into the crime of either murder, di ba? Murder or homicide, as the case may be. Dili ko na mahimo robbery. Okay? So, directly by overt acts. What do you mean by directly by overt acts? So, directly by overt acts means that the overt acts performed by the offender must be directly connected. Again, tanan yung buhaton, the overt acts, the external acts must be connected to the intended felony. And the intended felony is punished by law is one which is directly connected to the overt act performed by the offender, although he has admitted a crime. So here's an example. X won the lottery. X put the lottery money in a safe in his house. Y wanted to steal the lottery money in X's house. On that night, Y went to the house of X. In order to enter the house of Y, removed the jalousies and window of X's house. When Y was about to enter the house of X, a barangay tanod saw Y. Thereafter, Y was apprehended by the barangay tanod before he could enter X's house. So Y was charged with attempted robbery. So should X be convicted of attempted robbery in the cited example? Of course, no. Because the act of Y in removing the jealousy window of X is not directly to the act of robbery. Again, removing window, merely removing a jealousy window is not directly connected to the act of robbery. The act of removing the jealousy of the window will not necessarily ripen to the crime of robbery because once the offender is inside the house, the offender may either rape or kill or rob the occupants therein. So it's not clear yet that it's robbery because what if there's a girl there and the offender wants to rape that girl? Or maybe he wants to kill someone inside. Okay, so that's not yet a robbery. So what is the liability of X, if any? So the safest, okay, the safest crime nga pwede nato ikaso ni X is attempted trespass to dwelling because the act of removing the jealousy window, okay, sa balay sa laing tao is an attempted trespass to dwelling. It's trespass to dwelling punishable under the revised penal code. So if mag-remove ka jealousy sa window, okay, that's trespass to dwelling. Safest case na pwede na ito i-file sa usang tao is trespass to dwelling. Removing the jealousy of the window is an overt act directly connected to trespass to dwelling. It will necessarily ripen to the crime of trespass to dwelling. However, because the barangay tanod apprehended Y before he could enter the house of X, he did not perform all acts of execution by reason of some cause. Okay, some cause because the barangay tanod saw him other than his own spontaneous desistance. That's why it's attempted trespass to dwelling and not attempted robbery. People versus lamahag, wrong spelling. A person intending to rob a store made an opening on the wall of the store sufficient for his body to enter. His intention was to rob. Before he could enter, he was already apprehended. Now, can he be liable for the crime of robbery? Can such person be held liable of attempted robbery? What do you think? Of course, no. Why? Because his overt act of making an opening on the wall of the store is not an overt act directly connected to robbery. It's not an overt act directly connected to robbery. It is only an overt act directly connected to trespass to dwelling. Okay? Hence, he can only be held liable for attempted trespassing or attempted trespass to dwelling. Although his intention was to commit robbery once inside. Okay? Once inside, he may rob, he may rape, he may kill, he may injure the owner of the store. Therefore, it is not an act directly connected to robbery. Because if once inside, wala man takabalo, basig mang rape siya, or basig mo patay, wala man takabalo siyang intention good. That's why ang safest na tong i-file o case niya is attempted trespass to dwelling. If ever, due to some cause, nasakpan siya, etc. So, attempted. Baleros versus people. The woman was awakened by a man pressing a cloth soaked with a chemical on her face. The man was on top of her. She struggled. She was able to kick the man. The man jumped out of the window. She called on the guard, and then everyone came up to her. The case filed against the man was attempted rape. He filed a case for attempted rape against the man. So the man was convicted up to the CA of attempted rape. So was there attempted rape? The Supreme Court said, no. The overt act of pressing a cloth soaked with a chemical on the face of the woman is not an overt act directly connected to rape. It's not connected. The obvious intent was to make the woman unconscious, but once the woman is made unconscious, then the man may rape or touch private parts of the woman, or he may injure the woman, or may rob the property of a woman. Therefore, he cannot be held liable for attempted rape. Okay, once the woman will be unconscious, the offender may steal the belongings of such woman. Okay, he may touch the private parts of the woman, and that's acts of lasciviousness. So dagang ma-filing nga case if ever. So dili good siya overt act. It's not an overt act. The overt act of pressing cloth soap with a chemical in the face of a woman is not an overt act directly connected to rape. So when the overt act of a person is ambiguous, meaning unclear, insofar as the intended felony is committed, what we have is an attempt to commit an indeterminate offense. Indeterminate offense meaning you cannot determine unsa by crime iyang buhaton. Okay, it is which is a juridical standpoint as far as the RPC is concerned. So indeterminate offense, what's an indeterminate offense? So the overt act of a person, overt act, external acts directly connected to the crime. Okay? So in relation to the entire felony is ambiguous, unclear. Wala ta kabalo. The overt act of katong soaking gani o what is that? Ang cloth gi-soak og chemical in her face just to make the woman unconscious, etc. So it's an indeterminate offense. We don't know if after that, after the woman is unconscious, mo-rape siya, commit siya acts of lasciviousness, or the person will commit robbery. Okay? So it is necessary that the overt act must be necessarily connected to the felony. Only then he will be punished of the said attempted felony. Rivera versus People. So the victim was mauled, okay, hit with hollow blocks. Rivera brothers were able to pin him down on the ground. Suddenly, there was the siren of the police. So the Rivera brothers fled. So the medical certificate showed that the victim only suffered superficial injuries, only slight physical injuries. Yet they were charged with attempted murder. So, what is the criminal liability of the Rivera brother, if any? Of course, they are liable for attempted murder. Why? The first element was present. They boxed the victim, mold ba? They mold him. And their intention was to kill him. When there's intent to kill, the crime is either homicide or attempted murder. Since is in this case, duwa man, brothers man sila. There's abuse of superior strength. Therefore, it's murder. And second, they were not able to perform all acts of execution because of the arrival of the police. There was a cause other than their own spontaneous resistance. Therefore, attempted. The felony was not consummated because of the arrival of the police. Therefore, the non-consummation of the crime was because of the cause or accident other than the accuser's own spontaneous resistance. Why attempted murder? Why not slight physical injuries? Because there was intent to kill. Intent to kill was proven in this case. So if there's no intent to kill and then you inflicted injuries to a person, then the crime would be slight physical injuries or other crimes. But if there's intent to kill, then attempted murder. So the following are factors to determine whether or not there is intent to kill. Okay. Evidence of the motive. The nature and number of weapons used by the offender. Okay. Number of weapons. What was the weapon used? They boxed him, then katong hollow blocks, yeah. And when you hit a person with a hollow block, the victim could die. Okay. Because that's a hard material, solid material. Then the nature, number, and location of the wounds inflicted on the victim. Manner of committing the crime, Gimold, Manila. Okay? Then the acts and statements made to the offender before, during, and after the commission of the crime. Okay? Another example, we have here X and Y were fighting, and in the course of the fight, X pulled out a gun. Upon seeing this, Y ran away from X. With intent to kill, X aimed the gun towards Y and pulled the trigger. At the last minute, Y evaded the bullet. Is X liable for any crime? The answer is yes. The crime committed was attempted homicide or murder, as the case may be. Even if the victim was not hit, since the act of discharging the firearm was with intent to kill, it was already in the attempted stage. And such act of firing the firearm was already an overt act directly connected to the act of homicide or murder. Remember in my previous example, simple act of firing the firearm, firing the gun, it's an overt act directly connected to the act of homicide or murder. As long as nag-fire ka sa imong firearm, it's directed to a person. Okay? So in the same problem, X aimed the gun towards Y and pulled the trigger. Y was hit in the right shoulder. Y safely got away, and upon medical examination, the doctor said that Y's wound will heal within 5 days. So what crime was committed by X against Y? So X is liable for attempted homicide or murder, as the case may be. Why? Because the wound sustained was not fatal or not mortal. It requires another act for the crime to be consummated. Kiniga naman kasi mo right shoulder, and it would be impossible for the victim to die because the victim only suffered non-fatal or non-mortal wound. Okay? So no one would die by a non-mortal or non-fatal wound. That's the general rule. However, in this example, A shot B with intent to kill, B what was hit in the vital organ. So vital organ na. So he sustained a fatal mortal wound. However, he survived due to immediate medical intervention with doctor. So what crime was committed by A against B? So it is already frustrated homicide or murder, as the case may be. Why? Because due to the medical intervention, the victim survived. And the wound, okay, sustained by the victim was a mortal wound. And when we say mortal wound, pwede si victim mamatay or dili. As long as if na medical intervention, then the victim will survive. And the crime, muubo siya o frustrated. Okay? People versus Labiaga. Accused Labiaga was in the house of Gregorio Conde when suddenly he shot Gregorio in the forearm, only in the forearm. Gregorio shouted for help. One of his daughters, Judy, came to his rescue. However, the accused shot Judy to the stomach. Accused was charged with murder and frustrated murder. So whether or not the accused is guilty of frustrated murder against Gregorio Conde, the answer is no. Gregorio Conde failed to present proof that the wound he sustained was fatal. Okay, a shot in the forearm is non-fatal. Okay, so the wound sustained by the victim is non-fatal or non-mortal. The crime is only in the attempted stage. The reason is that it is only when the wound sustained is mortal or fatal that it can be said that the offender has already performed all the acts of execution which would produce a felony. However, the felony was not produced by reason of some cause independent of his will, that is the immediate medical intervention. Example, X and Y are enemies. In one instance, X saw Y outside his house. Angered, X took his father's gun. The gun was not used for a long time, therefore X took and aimed it. An aim and within to kill, pulled the trigger of the gun. However, the gun did not fire the shot. X pulled the trigger 4 times, yet no bullet came out. The gun was jammed. Okay, so what is the liability of X, if any? So X is liable for attempted homicide only. The overt act, again, overt act or external act directly connected to the crime. So the overt act of pointing the gun to Y is directly connected to the crime of homicide or murder, as the case may be depending on the circumstances. However, the gun jammed. So X was prevented from performing all acts of execution by some reason. Okay, there's a reason. The gun jammed other than his own spontaneous decision. Therefore, the crime is in the attempted stage. X and Y are enemies. In one instance, X saw Y walking in the streets. X took out his gun from his house with the purpose of killing Y. X aimed the gun at Y. The very moment Y's son ran towards Y. Upon seeing the son, X did not shoot Y. So what crime did X commit, if any? The answer is nothing. Okay? Although X commenced the commission killing Y through overt acts, X did not perform all acts of execution which should produce the felony. Because remember, he desisted from killing Y, di ba? Upon seeing the son of Y run towards him, he voluntarily and spontaneously desisted na. Okay? Therefore, no crime. What's the difference between attempted felony and impossible crime? So in attempted felony, the crime may be accomplished. It is not accomplished by spontaneous desistance. In impossible crime, the felony cannot be accomplished. Bisan pagunsaon. It is inherently impossible or the means employed is inadequate or effective. So example, one good example is that um, A wanted to kill B. So A took out a gun and shot at B. However, the gun did not fire. Why? Because the gun was not loaded. It was empty. Therefore, that's an impossible crime of homicide or murder, as the case may be. Why? It is impossible to commit the crime of homicide or murder when the gun is empty, because it is inherently impossible to commit the crime. Why? The gun was empty. So, I mean, you get the point. Walay unod ang pusil. Therefore, the felony can never be accomplished. Why? It was empty. But what if naiunod ang pusil, however, the gun jam? The crime is attempted felony, not impossible crime. Why? Because what if wala ni jam ang pusil? Okay? What if the gun was not jam? So there's a possibility nga ma-accomplish pa ang crime because there's a bullet. So in impossible crime, wala man dyo'y unod. Bisan pag unsaon pa nimo nagpusil, walay unod ang bala, it's inherently okay impossible for you to commit the crime of homicide or murder. However, if the gun was loaded and jamra, there's a possibility man po na the crime may be accomplished. Why? What if wala ni jam ang imong kusil? What if okay ra siya? Doon na siya bala. Okay? The crime may be accomplished, therefore attempted. Okay? X and Y are enemies. In one instance, X saw Y outside his house. Angered, X took his gun of his house. X took aim at Y and pulled the trigger of the gun. However, the gun did not fire the shot. X pulled the trigger again, yet no bullet came. Upon inspection, X found out that the gun was not loaded. So what crime did X commit? So X is liable for an impossible crime of homicide or murder, as the case may be. So had the gun been loaded with bullets, X would have committed a crime of murder. However, because the gun had no bullets, it is inherently possible to commit a crime of murder in any circumstances. Sa pag-usaon pa ni mo pull ng trigger when your gun is empty. Okay? Dili ka ma-commit of crime of murder. Okay? Frustrated stage. So there is frustrated felony. The offender performs all acts of execution which would produce the felony as a consequence, but which nevertheless do not produce it by reason of causes independent of the will of the perpetrator. So elements, the Supreme Court gave the elements of frustrated homicide. Okay. Offender performs all acts of executions. All the acts performed would produce the felony as a consequence. For example, A wanted to kill B, so A took out the gun and shot B in his vital organs. So that's a mortal wound. Therefore, but due to the medical intervention of the doctor, B survived. Therefore, it's frustrated. And because if wala medical intervention, the victim could have died. Okay? Therefore, ma-consummated na crime, di ba? So because of by reason of causes other than the will of the perpetrator, due to the medical intervention of the doctor, the victim survived. Therefore, frustrated. Okay. Example, A wanted to kill his own father to get his inheritance immediately and wanted to be rich. He went to the drugstore and bought poison. Before going home, he went to the house of his friend and told his friend, "Tonight I will be rich. I will be poisoning my father. I will be a millionaire." After telling that to his friend, A ran to his house. Upon reaching his house, he took the poison out of plastic. Meanwhile, the friend went to the police and told the plan of A to kill the father. The friend and the police went to the house of A and the father. Upon reaching the house, they saw A in the act of taking out the said poison from the plastic bag. A was arrested. Now, is A liable for attempted parricide? Answer is no. Why? Because the act of buying poison, taking out of the plastic are only preparatory act, and preparatory acts are not punishable as a general rule. It is not yet an overt act directly connected to parricide. Remember, ni bayra kag poison, then ni imurang gikuha sa plastic ang poison. Okay, what if you will use it? You will use the poison to kill insects or pests. So wala pa na to nahibalan yung intention whether to kill the father or maybe yara da itong gipalig nag-joke na day siya para mapatay ra sa mga insects or pests, di ba? So it is not yet an overt act that is directly connected to parricide. He may use the poison not really to kill the father. He may use it to kill insects or pests. Therefore, he cannot be liable for attempted parricide. Okay? So, example again, A mixed the poison to the juice of the father and then he gave it to his father. Okay, he mixed na sa juice, gave it to the father. The father was about to drink the juice with poison. However, since the father was clumsy, the glass fell from the hands of the father. Is A liable for attempted parricide? Because of the accident, nahulog. Okay, because the father was clumsy, nahulog ang glass. So yes, he is already liable. The moment he poured the poison in the juice of the father, he gave it to the father for him to drink. He already performed an overt act directly connected to parricide. However, the parricide in this case was not consummated, and because he was not able to perform all acts of execution by reason of an accident, because of the clumsiness of the father, the glass fell. So it was purely accidental because the father was clumsy and the glass slipped from his hands. Therefore, attempted parricide only. In the same problem, after mixing the poison in the juice, he gave it to his father. The father was about to drink the juice with poison when A took pity on his father, naluoy siya, and had a change of heart. He immediately grabbed the juice and threw it on the garden. Is A liable for attempted parricide? The answer is no. He's not liable of attempted parricide because the act of mixing of the poison with the juice is an overt act directly connected to parricide. However, he was not able to perform all acts of execution by reason of his own spontaneous resistance. Again, he was not able to perform all acts of execution by reason of his own spontaneous resistance. Therefore, he is absolved of criminal liability. Because for one to be liable in the attempted stage, the reason for the non-consummation of the crime must not be his own spontaneous resistance. There must be some cause or accident. Again, there should be some cause or accident. But in this case, wala niya gi-perform ang all acts of execution, wala gi-perform sa offender ang all acts of execution by reason of his own spontaneous resistance. Iyang kaugalingon. Therefore, A is not liable for attempted parricide. Okay, in the same problem again. A mixed the poison with a juice and gave it to his father. The father drank the juice and was poisoned. Giinom na sa father ng poison. Suddenly, he was already showing signs of being poisoned. He was chilling. Upon seeing his father in that condition, he immediately administered an antidote to his father. After that, he immediately rushed his father to the hospital. The father survived. The doctor said, were it not for the antidote given by the son, the father would have died. So is the son liable for attempted parricide? No. Okay? He is not liable for attempted parricide. The moment the father drank the juice, all the acts of the performance of the crime has already been done. The offender has already performed all acts of execution necessary to consummate the crime. However, the crime was not consummated. So is the son liable for frustrated parricide? No, in prostrated parricide, although the offender has already performed all acts of execution, the reason for the non-consummation of the crime must be a cause independent of his will. Diba? In prostrated parricide. Okay? But here in this case, the reason for the non-consummation of the crime is the own will of the son. Therefore, the son is not liable for frustrated homicide. Okay? So what is the liability of the son? The son is liable of physical injuries. So the crime of parricide is not then graded to physical injuries. So physical injuries depending on the required medical intervention. So if 1 to 9 days on medical intervention, that's slight physical injuries. If 10 to 30 days, that's less serious. And if more than 30 days, that's serious physical injuries. Okay. So it is a well-settled rule that there is no frustrated theft. In the case of People versus Valenzuela, the Supreme Court held that there is no such thing as frustrated theft. Theft, pagpangawat pa. So under Article 308, theft is committed when a person takes the personal property of another with intent to gain without violence, force, intimidation upon persons, or force upon things without the consent of the owner. And theft can admit only either attempted and consummated stage. Again, no frustrated stage in theft, only attempted and consummated. Because the moment the offender gains possession of the personal property of another, unlawful taking is already committed. Example, imong gikawat ang cellphone sa imong classmate. So imong gikuha. Okay? Nanani mo ang iyang cellphone. Okay? You have the intent to gain. Okay? without violence or force or intimidation upon person or force upon things, and without the consent of the owner, your classmate. So theft is consummated already. Again, the moment the offender gains possession of the personal property meaning movable property, like a cell phone, it can be moved. Okay, unlawful taking is already consummated. So even if he has no opportunity to dispose the property, and the moment the unlawful taking is complete, theft is already consummated. Hence, there can be no instance of frustrated theft. Okay. So example, a woman went to Rustan's and bought perfume. While she was sitting and the sales lady was taking the perfume in the counter, she saw a new line of lipsticks on the glass shelf. She went there, but it was locked. Saw the key on the table and opened it. Took one and slipped in inside her bag. Closed the glass. Placed the key back on the table. The sales lady arrived and gave her the perfume. She was about to leave Rustan's when suddenly a certain device detected and made a sound. So the unpaid lipstick was discovered. So what crime was committed by the woman? The woman committed consummated theft, even if he has not yet left Rustan's. The moment she took the lipstick from the glass shelf, taking is already complete, and theft is already consummated. So in the same problem, the woman took the lipstick and slipped it inside her bag. Suddenly, she has a change of heart. She took the lipstick from her bag and placed it back on the glass shelf and closed the glass and locked it. Now, did the woman commit any crime? Of course, yes. Again, uh, the moment the woman took the lipstick from the glass shelf, taking is already complete and theft is consummated. So, minsan pag iuli na nimo, consummated na ang crime of theft. Okay? So, did the woman commit any crime? Yes. She is already liable of consummated theft. So, the moment she took the lipstick from the glass shelf and placed it inside her bag, taking is already complete. Therefore, theft is already consummated. Her change of heart would not amount to desistance. It's too late na. Desistance will only lie in the attempted stage, but never in the consummated nor in the frustrated stage. What is the effect of returning back the lipstick? Uh, there will be there will only be no civil liability. She will not be made to pay the lipstick. Why? You return. Because she returned it, but nevertheless, she is already liable for consummated theft because unlawful taking is already committed. So, in the same case, the woman opened the glass shelf. She was about to take the lipstick when suddenly there was this hand placed on top of her hand before she could even get the lipstick. Okay, so iyang gikuha ang lipstick but nay ni place sa kuan dakpan siya before she could even get the lipstick. So unknown to her, her acts were being seen on a CCTV camera, and the head of the administrative office immediately went to her upon seeing that she was about to take the lipstick. So is the woman liable of any crime? Yes, she is already liable for attempted theft. So, a note, remember, a note was posted on the glass shelf saying do not open, ask for assistance. So the moment she opened it with the use of the key, it shows her intent to gain. Remember, there's a note na nga, bawal open, ask for assistance. So the moment she opened it with the use of the key, it shows her intent to gain. So it is on the attempted stage because she has not yet taken possession of the personal property. Okay? Nasakpan man siya. Okay? Therefore, attempted stage siya. And also, no frustrated rape. As a rule, there is no frustrated rape. Only attempted and consummated. So in the case of People versus Pareha, the Supreme Court held that rape is consummated by the slightest penile penetration of the labia majora or pudendum of the female organ. So once, okay, ang penis na penetration sa labia, okay, that's rape. So without any showing of such penetration, there can be no consummated rape. At most, it can only be attempted rape or acts of lasciviousness, as the case may be, depending on the circumstances. Again, when you force someone to have sex with you, then imong gipagawas ang imong penis, then you touch sa labia majora, automatic consummated. Okay? A woman was raped Okay, she filed a case of rape against the man. In her open court testimony, she said that she was not sure if the penetration was complete. Likewise, in the medical survey, it shows that her hymen was not lacerated. It was intact. Now, can Sedman be liable for consummated rape? The answer is yes. Because according to the Supreme Court, rape does not admit of any frustrated stage, only attempted and consummated. And rape is consummated the moment the penis has touched the lips or the labia of the pudendum of the woman's genitalia. Mere touching consummates the crime of rape. Okay? It is not necessary that there is a full and complete penetration sa hymen. Okay? Or maybe na laceration. Okay, it's not necessary. Yan na laceration. The hymen may remain intact, yet rape can be committed because what is required is the penis must touch the lips or the labia. Okay, so mere touching sa penis and the labia consummated. People versus Lizada. So the man was still in his shorts. His penis has not yet even touched the genitalia of the girl. He only touched the private parts of the girl. How come the conviction was for attempted rape and not mere acts of lasciviousness? So, according to the Supreme Court convicted the accused of attempted rape, taking into consideration the three other consummated rapes that has been done by the stepfather and the daughter. Considering that in these three former acts of rape had been consummated, the obvious intent of the stepfather is to rape the girl. Okay? So, kay sige na rape na yung amahan de ani kaning si stepfather sige na rape. So, katong fourth act of rape, wala na siya gi-considered as a mere acts of lasciviousness. Okay? Because of the three consummated rapes nga gibuhat si stepfather sa iyang daughter, the court came to a conclusion that it's pretty obvious, okay, that the stepfather did that to rape the girl. That's why attempted. Okay? So, not acts of lasciviousness. Kaya thrice naman yung gi-rape. So, meaning, katong recent niya nga acts, dili to acts of lasciviousness, but attempted rape na. Dito gusto pa dilo. So, it just so happened that he saw the son peeping and so he went out of the room. That is the reason given by the father. Therefore, attempted. There's a dissenting opinion. So according to a justice, if that is the reason given without the said facts that there has been consummated rape for the past three acts, it should only be acts of lasciviousness. So according to this justice of the Supreme Court, only acts of lasciviousness now, or at least attempted rape if there is an intent to lie. So in the case, the stepfather was still in his shorts. The penis has not yet touched even the outer portion of the woman's genitalia, absent the facts that there were three former consummated rape. It should only be acts of lasciviousness. Because the amount to at least attempted stage, it is necessary that the penis must touch at least the outer portion to show intent to lie. The man was still in his shorts. How can you know that there was intent to lie? It is only a different ruling because there were three previous consummated rape. The essay considered all these, saying that the obvious intent of the stepfather was also to rape the daughter. He also has a point naman. Because the stepfather nagsulot pa siya siyang shorts. Therefore, pwede siya acts of lasciviousness. However, this is only a dissenting opinion. And majority of the justices voted that it's attempted rape and not mere acts of lasciviousness. And we should follow this decision. Acts of lasciviousness versus attempted rape. So acts of lasciviousness, so the penis only touched the outer portion of the vagina. Okay, it did not touch the labia. Okay, and there is no intent. As long as there is no intent to have carnal knowledge of the woman, that's acts of lasciviousness. In attempted rape, the penis only touched the outer portion of the vagina, and intent, okay, to have sex or carnal knowledge with the girl is evident. Klaro kayo. The penis is in the position to penetrate the labia. Okay, that's attempted rape. Now, so of lasciviousness, there is no intent to have carnal knowledge with the girl. Material crimes. So when we talk about material crimes, they are crimes which admit stages of attempted, frustrated, and consummated, like attempted murder, uh, frustrated murder, consummated murder. Like three stages. Okay, material crimes again. Board exam purposes. Material crimes are crimes which admit stages of attempted, frustrated, consummated. Formal crimes gani, which do not are crimes which does not admit any stages. It only punishes a consummated stage. So when we talk about formal crimes, wala na siya stages. Okay, always consummated. So the following are considered formal crimes: physical injuries. So when you inflict physical injuries, that's consummated na. Slander, adultery. Okay. So thank you very much for listening. Have a great day.